Schneider is our antitrust expert. And I think for many, his reputation precedes him. And we are extremely fortunate and excited to be able to share his expertise with you. We are going to have about 20 minutes of a presentation and then 10 minutes for questions and answers. And I will let Brian share anything else he wishes to share about himself and get started. Thank you, everyone, for joining us.
Thanks, Linda, and thanks everyone for joining us in the morning. It's good to be with you. For those of you who don't know who I am, which is probably most of you, despite Linda's kind words, I am a lawyer. I'm with the law firm Arent Fox Schiff. I'm in our Washington, D.C. office. I was just up in our New York office yesterday. And I lead our associations and antitrust groups with several of my partners. And I specialize in multiple listing services and realtor associations, especially in the last few years when a lot of those organizations have needed a lot of antitrust guidance. And so I've been helping along the way to navigate the last couple of years, helping to defend several of the associations when they were sued in these class actions. And so I'm deep in it. And I'm going to try to give you a flavor of where we're headed and where we are today, where we're headed. I really want you to engage with us on questions. I'm going to try to get to all of them and leave plenty of time for that. So before we talk about sort of where we are now and what's ahead, I always think it's helpful just to remind ourselves where we were that led to where we are. And I think it's just helpful really quickly to just remind ourselves that, less than 7 months ago, before the settlement was announced, we were looking at 28 plus active class actions around the country, suing nearly 200 realtor associations, MLSs, and brokerages. Several of the class actions that I was working with MLSs in involved brokers with fewer than 10 agents in their office. So they were looking at certain bankruptcy just to afford the legal fees. And the cases were seeking hundreds of billions of dollars from those brokers. And in an antitrust case, every single defendant is liable for the full set of damages. So if you're the only defendant left, you're on the hook for all the remaining damages. So it's a huge threat to be a defendant in one of these cases. And so as the industry was sort of looking down the barrel of these many cannons, the settlement was announced, as you know. And in the last 7 months, you've all pivoted your businesses in many ways and the communications you've had with your clients in many ways because of the settlement. And so I'm not going to bore you with the information that you've already absorbed. I'm going to focus on kind of what's coming. But it's important, again, to sort of remind ourselves that we were being alleged, all of our industry participants were alleged by sellers in cases and buyers in cases and by the DOJ that we were all colluding. And we were colluding not necessarily by meeting in dark smoke-filled rooms and agreeing on the prices we were going to pay, but by using the existing systems and the sort of various rules of checks and balances that were in place by the MLSs and by NAR to keep commissions up. That's the baseline allegation. It was a complicated allegation, and the plaintiffs got lucky and they convinced a jury that they were right. And that's really what brought us to today. I think it's important, though, to just remind yourselves of that context because it informs what we need to keep thinking about as an industry going forward. So what happens now that the settlement was approved? So just 2 weeks ago, the federal district court judge in Missouri finally approved all of the settlements that were out there, including NAR's settlement, which means that those settlements now can proceed. So what happens now? We know that the MLS rule changes will stay in place. No modifications to what was implemented by the MLSs. As you know, no offers of compensation can be made in the MLSs. The MLSs are not going to track how you're getting paid. And of course, the contracts and disclosure requirements for both listing agreements and buyer rep agreements, that you're all familiar with. None of that is changing. I think there was some speculation that things might be altered or the judge might tweak here or there. No changes at all. The judge recognized that the settlement terms were implemented, that things were working, that there are certainly cases of confusion out there, but that those would get resolved. So what does it mean for agents? One of the things that I think has been lost in all of this discussion around the MLS rules is that the settlement agreement, really importantly, releases all of you, every realtor, agent, broker in the country that could have been sued as part of these cases, has now been released, protected from lawsuit, but only if you comply with these 5 rules. And you've seen these rules, you're familiar with them, I'm sure, but it's important to recognize that these 5 rules are actually applicable to you directly, not through the MLS. So if brokers or agents are out there not complying with these rules, having the buyer agreement in place, disclosing your offer of compensation and approved by the seller, disclosing that commissions are not set by law, all the rules that are listed here on this slide. If you're not complying with these, you're putting yourself at risk of being sued without any protection from the settlement agreement, meaning they could go back many, many years against you and your company because you're not complying with these 5 rules. So I always like to emphasize the importance of these 5 rules, not to just sort of slough them off as any old MLS rule that you may or may not think that you agree with or like. These are important parts of the settlement agreement that now are just simply going to be folded into all of your businesses while the settlement agreement is in place, and I think that's really important. All right, so what litigation is still ongoing? The settlements being approved and finalized does not end magically all the litigation and turmoil that's out there. And so there are still things that need to be resolved. So as I mentioned, there was 28 plus class actions out there brought by plaintiffs who were home sellers, trying to bring the same claims that had been brought in the Merle and the Sitzer cases you've probably heard about. So those cases all now need to wind down, and most of them will soon be dismissed under the settlement. There have been several class members who have appealed the approval of the settlement. So that final approval now is sort of pending an appeals court review, which will likely happen in the first half of next year. So those appeals are going to delay things a little bit more. Those 28 plus class actions are going to kind of linger a little bit longer. But they're ultimately almost certainly going to be dismissed. But again, that appeal is going to delay things. There were about, I think the number was about 50 individuals who were home sellers who opted out of the settlement. They affirmatively submitted a form that said, I do not want to be part of the settlement. I don't want my check out of the settlement funds. It is very likely that they did that because they are working with the plaintiff's lawyer who seeks to bring the lawsuit themselves. My apologies. And so if they want to bring that lawsuit themselves, they're going to have to sue the broker that they work with. And there might be that sort of several dozen cases sort of still to be filed out there in the coming months. It remains to be seen. Those will be much smaller, though, because it would be an individual case, not a class action, and it would be brought on behalf of those individual plaintiffs just for their single damages. Buyer class actions. So there are a few buyer side cases that will continue. You've probably heard about them referred to as the Batten cases. And those cases are essentially using the same theories as the Merle and Sitzer cases, but they're brought on behalf of buyers, saying that the buyers overpaid. Those cases have been sort of dwindled now because of the settlement and because of various legal maneuvers and legal arguments that were successful in those cases, but they still will sort of proceed out there in the courts until they are either settled or resolved. And then finally, we're watching closely the DOJ. I've been speaking with DOJ lawyers in their investigation. They are actively investigating the industry still. They have not been engaging as much directly with NAR, but they are investigating realtor associations, brokers, et cetera, because they are trying to monitor and evaluate whether the settlement agreement is now being implemented in a way that is anti-competitive. They're not, to my knowledge, they don't have any evidence that it has been, but they are looking to see whether the industry is implementing it in a way that allows them to collude on fees and commissions. So they're looking over everyone's shoulder still. There are subpoenas out there to realtor associations and MLSs and brokerages to get their emails and get their forms and their contracts and their communications and their training to understand how exactly are you now doing this with the settlement agreement, and is it going to be competitive? You may have heard that the Justice Department filed a brief in the case regarding the settlement, sort of questioning whether the buyer's representation agreement might be used to be anti-competitive. They had no support for that statement. They had no explanation of why they were raising that as a question. They had no examples. They have no facts. But we know from that brief now that they're looking at, how are you implementing this? Are you doing it in a way that maintains competition? So what are we watching for? How are we thinking through how you can avoid creating risk going forward? And what is the industry doing? Well, we're watching for how are the MLS rules being enforced. It is still critical that the MLSs and agents and brokers who participate with the MLSs comply with those rules. What I'm seeing in the work that I do with MLSs around the country is that most agents and brokers, the vast majority, are complying with the rules. They're getting the agreements they need. They're not trying to sneak offers of compensation into the MLS through any of the sort of cutesy games that we heard folks were going to do around, putting something in a picture and using the picture to communicate an offer of compensation. I don't think that's happening, at least not on any sort of wide scale basis. And the few instances where folks have probably made a mistake in what they put into the comments have generally been cleaned up. But it's important that everyone continue to take it seriously. And as you recall, as I was mentioning earlier, there are rules that apply directly to you that have to be complied with to maintain compliance with the settlement. Forms. So I think the big message on sort of standard forms is they're going to keep changing. They're going to keep getting updated and fixed and improved. And I think the emphasis on the word is on the word improved. To the extent that the forms aren't working for you, you should figure out whether your organization should create its own version of a document. There's no requirement that you use standardized forms. And the Justice Department and plaintiffs' lawyers and the industry in general is watching out for whether or not you're using those forms in a compliant way. Are you using standard forms to standardize what you get paid? If the answer is no, we are every time deciding on our own payment rate, and we're filling it into a form that makes it easy to fill in based on what I work out with my individual client, great. But if you're using it to facilitate conversations with other brokers about what numbers are you using, how are you negotiating that number, watch out. That's where you get into trouble around price fixing. On a sort of unrelated basis, we're also looking out, there are lawsuits right now challenging the linkage between the state, local, and the national associations of realtors, alleging that by requiring you to be a member of 1, 2, and 3, that's also an antitrust violation. I don't see those cases as having legs. Other industries have been challenged on similar sort of bases and have prevailed. There are lots of pro-competitive reasons why the organizations would do what they're doing. But they're going to make headlines. The cases are going to proceed for at least a little while until they're either dismissed or resolved. But I think it's something to watch, and it's conversations to have. The other piece that I'm watching and that I'm now including in all of my discussions now with agents like you and brokers and MLSs around the country is this notion of information exchanges. So remember when I was talking about the use of forms and whether forms are facilitating the ability to still collude on price. Well, there's another mechanism that is commonly the target of antitrust claims. And that is, they're known as information exchanges. So the idea is that there's some central body, whether it's an association or a survey company or a private actor, that collects data around what fees people are charging, what prices people are charging, and then shares that data back out with those people so that they can set their prices. That's an antitrust problem if it's done that way, where you're collecting data so that the recipients of that same data can then go out and set their prices in a similar way. That creates a price fixing risk. So think about it, on a simple basis. If a local company were to survey all the brokers in, East Meadow and say, what are you charging for your listing fees? And then the next day, go back out to those brokers and say, all right, here's what everyone reported they charged yesterday for listing fees. Well, if those brokers then use that information to make their price around that average, that's a price fixing agreement. And so you've got to have sort of those multiple steps to be a problem, but it is often alleged to be a problem when those kinds of information exchange opportunities occur. So what are we watching for? Well, there are websites out there that you've probably seen on Facebook, or maybe you've poked around on, where folks are publishing their offers of compensation or their listing agreement fees or what they'll pay the buyer rep. Well, that could be okay on its own, but if it's used to sort of get a sense of what people are charging or what people are sharing for compensation, that's a problem under the antitrust laws. I talked to a title company the other day, and the title company was explaining to me that when they meet with their broker clients and sort of schmooze about business, one of the things they do is they share data from recent closings about what brokers in the area are getting paid on the sell side and the buy side. And I said, well, why do you do that? And they said, well, it's really useful for the broker to understand what is going on in their local closings so that they know what to charge. And I smiled and I said, well, if that's how the brokers are using it, then you're acting as an illegal information exchange where you're gathering that local confidential information that's not otherwise available, and you're pumping it back out to these brokers so that they can set their prices in a common way. That creates a huge risk. So, it's really important to think about, why am I engaging in this conversation or this survey or this meeting or this report around pricing? And if it's to set my own price in a similar way to my competitors, you got to check yourself, because that's where you get into trouble. And we know, realtors are social folks very often. They get together, they talk about business. Got to be really careful, even if it's among a small group of competing agents and brokers. If you get together and you start talking about what you're charging, and you do it with the thought that, well, if we all just sort of start charging the same amount, it's going to be, easier to negotiate, you're going to run into an antitrust problem again. So that's the big challenge for you. And it doesn't matter that you're doing it on a public website, or you're doing it through a private company, that it's not an association. It doesn't matter if you sort of share it all on a private channel in Instagram. Doesn't matter. Any mechanism to share pricing information for the purpose of collectively setting your prices can be problematic. So that is where we stand today. I saw a couple questions on these rules. There was a question of what does number 2 of the 5 rules mean? Number 2, if making an offer of compensation, the seller must first approve it in writing. So if you, as the listing broker, are going to offer to share any compensation or offer any compensation, that must be approved in writing by the seller. No matter what number it is, how you're communicating it, if you're making an offer, a blanket offer of compensation, it has to be approved in writing by the seller. Hopefully that clarifies it. I saw 2 questions pop up on that particular point.
Brian, I can help you with some of these questions, so I
Sure.
can read these out to you.
Okay.
We had a question this morning. What do we input into OneKey, which is our MLS, for a residential rental where the fee paid by the tenant would be split between the listing and buyer's agent? How do we correctly disclose this fee structure?
So I don't know how OneKey has set it up. I'm not their lawyer, so I really can't comment on their implementation of their rules. As a general matter, most MLSs have put the sort of the same rules in place for rentals as well as for sales because the same problem can arise. And so, if you're offering compensation, you've got to manage it separately than simply in the MLS. But I don't know how OneKey has done it. So I would encourage you to ask that question to them.
Great, thank you. What if you keep the data internally so others in your office are aware of the cooperating compensation and don't have to reach out to the listing agent?
So information within a brokerage is not anti-competitive if it's within the brokerage itself. So as a general matter. So if you are, sharing with your fellow agents within your brokerage, what terms are being offered by your seller, and it's not going outside your brokerage to share with other brokerage. So it's really just sort of a dual agency situation. That tends to create a different arrangement because it's within one company. It's kind of like, if 2 divisions of Coca-Cola were to share their pricing strategy on, Coke Zero and Diet Coke, that's not anti-competitive. But if Pepsi and Coke were to get into the room and start talking about their pricing strategy, then it's a problem.
Thank you. Another question, how do you go around the FB explanation to actually safeguard yourself?
I assume FB being Facebook.
I assume as well.
How do you go around the Facebook explanation? Whoever asked that question, if you could maybe clarify it, or if any, I don't know if Linda or Liz, if you have a better sense of what they mean, I'm not sure what that's referring to.
Okay, let's have that person type a clarification and I'll move on to the next question.
Yeah.
Can you comment on the recent New York Times article about NAR's other nonprofit entity?
So the only comment I will make to you is go check out NAR's response on their website. If you just Google NAR and the acronym for the nonprofit entity that's covered in the New York Times, I think you will be pretty surprised at how wrong the New York Times article actually is. I certainly was pretty shocked by the discrepancy in the facts that the New York Times article did not cover what NAR's position was. Now, it may be that there's a dispute of fact, but I was pretty shocked at how the New York Times article did not cover what NAR's position was on those.
Okay. Can you better clarify rule number 5, please?
Sure. So I can take a shot. So in the sort of MLS sense, if you're creating a report for your client of properties to come look at, you can't filter out using the MLS tools or using your search tools what properties you give to your client to look at based on the amount being offered to pay your fees. Now, that's much harder to do now that the MLS doesn't have that data, and so the analysis is a little harder. The process is a little harder, but even so, if you are preparing a report to your client and you know that some properties are offering compensation and some aren't because you've called the agents or you otherwise know what they're offering, you can't filter out those based on what's being offered. What you can do is say, look, I've got 10 properties for you to look at, and here's what we know about them. These 3 are offering this to cover my fees. These 2 are not. These 3 are doing this. So inform your client. Be transparent with your client. I would think it adds value and shows that your knowledge and helpfulness. But at a minimum, it complies with the settlement by informing your client rather than hiding the information from your client.
Thank you. Can you speak to the distinction between a brokerage setting prices for their agents? Is that allowable?
It is allowable, yes.
Then there was sort of a follow-up. For rentals, it's actually landlords asking tenants to pay the landlord's agent. How is that still in compliance with the settlement? It's not an offer of compensation.
Right. So at least as I understand that, and I've certainly been there when I've rented, when I've been a tenant, is you get to the signing stage and you have to pay sort of first month's rent and you pay the landlord's broker as part of the transaction. That's perfectly allowable. The question is it are you allowed to communicate it in the MLS? And I have my own personal view on whether you can or can't, but I really don't want to step on One Key's toes. Again, I would encourage you to bring that one to One Key if they haven't answered it. They should have a clear answer of whether a landlord can say in their property listing in the MLS that the renter must pay the broker, the landlord's broker fee and what that amount is. They should be able to answer that for you.
Great, thank you. Then someone wrote, you sort of discussed this, but can you expand on how, as a broker, the line between discussing the changing compensation landscape to educate ourselves and remain competitive and stay away from being exposed to claims of collusion and price fixing?
So you're asking a good and hard question to answer simply. I think an example I would give you is that, talking with your fellow agents at other brokers about, tactics for how they're negotiating and how they're communicating, that can often be a great practice to understand best practices or how they're approaching things. But agreeing with them to use a particular tactic or to use a particular pricing strategy, that's where you get into trouble. And so the way I like to put it with a lot of my clients is if you are sharing best practices or critiques of best practices, I like to do it this way, I find that it's helpful. That tends to be okay. But if you're leaving the conversation with a sense that everyone in the room or some large group of the people in the room are going to use one tactic, that might be problematic.
Okay, thank you. Somebody asks, number 4, is this offering a free market analysis or CMA?
Yeah, so great question. So the key is you can't say that I'm gonna work for free if you are in fact getting paid by anybody from any source. That's the key. So it's not just that you can't just say, I give you free stuff. You can say, I give you a free CMA. I'm happy to take you on a tour with no cost, assuming you actually will earn nothing for that service. That's the key. The allegation was that agents were telling clients, this is all free to you. And when we get to the closing table, the other side will pay me. And I think, the solution to address that allegation, because I'm not sure folks were actually having that conversation in that way, but if they were, the way that this was addressed in the settlement agreement was to say, look, you can't say that you're free unless you're actually not getting paid from any source. I hope that's a helpful answer.
I hope so too. I know we're just about time, but if we have time for a few more questions, somebody asked, is it legal to call an agent ahead of time to ask if the seller is offering compensation? I thought that was steering.
So it's legal to ask. as long as you then are presenting that property to the client, regardless of the answer. So, if you've got 5 properties that you want to, that you think your client might be interested in, and you call all 5 agents, or you call one of the agents and find out whether or not they're offering compensation towards on a blanket basis, you can't then change that list for your client based on the answer. That's the simple outcome there.
Great. And then somebody asks, what if my buyer only wants to see properties that are paying my compensation? Is that okay to only show those properties?
So I think there's a fine line here. So let's say, yeah, you have that conversation with your client, and the client says, look, I can't afford anything where they're not going to cover your fee, which I think is a lot of clients are going to say that. The question for you then is, do you give them the information about properties where you don't know whether they're going to cover the fee, knowing that that's negotiable in the offer? Or do you give them only properties where there's a blanket offer in advance? Neither of those two options is prohibited by the rule, but I think the more conservative, wise choice under the settlement agreement and from a client relationship perspective is to give them the fuller picture. These 2 properties, the seller has said they are not willing to pay anything at any time. So even if we bring our offer to the table and we ask them to cover my fees, they're in advance telling us no. Do you still want to see those 2 properties? These 2 properties, they're not offering anything, but it's going to be negotiable, in the offer of whether they cover my fees. Do you want to see those properties? That's the kinds of conversations I'm recommending generally that folks have, so that there's transparency and openness, even if your client is saying, don't show me properties where there's no coverage, because the answer is, if there's no offer of compensation, that doesn't mean the seller necessarily isn't going to cover the fees of the buyer's broker, because what we're seeing across the nation in every market is the sellers and the sellers brokers sort of glomming on to the new model of charging their client a certain fee, and preparing their client that they likely will be asked in the offers that come to the table to cover the buyer's broker fee, so that their selling client is prepared for that request. But a lot of folks are not making offers of compensation on a blanket basis. They want to see what the other side comes in and asks for.
Great, thank you. 2 final questions, if you don't mind, Brian.
Sure.
Is a buyer agreement required if your buyer is a customer and not a client?
So I'm assuming what that's saying is, you are not providing brokerage services to that person. You're serving them in some other way as a customer, and that's always a fine line of whether you're actually serving them in a brokerage manner or in some other manner that doesn't cover brokerage services. As a general matter, if you are going to take someone on a tour, you should have an agreement with them that discloses whether you're going to charge them anything. That's the simple answer.
Great. And then last question, is it legal to not disclose what the seller is offering if a buyer's agent calls? Also, if the seller has a very low contracted comp, but they've verbally told you they'd consider a higher comp based on your offer price, can you suggest the buyer's agent just request what they want in their offer?
Yeah, look, so these are the conversations to have with your seller client. Absolutely. Both of those permutations are up to you, between you and your seller client. If you've told your seller client, look, we're going to make a blanket offer of X% so that every, broker has the same incentive to come see your property. And then when agents call, you're only telling that to some agents and not others. You have to ask yourself whether you're serving your client properly and whether there's a fiduciary breach there in how you're serving your client. But if you're telling your client, here's what we're going to do, we're going to promote a blanket offer in these cases and we're not in these other cases, and your client is sort of thinking through that with you, and there's not a fair housing, problem with what you're doing, those are the conversations to have with your client.
Great. And then I see that Gilda did say Facebook is what she meant. So how do you go around the Facebook explanation to actually safeguard yourself? So I guess maybe in terms of social media in general.
Yeah, look, I'm not exactly sure what she's talking about, the Facebook explanation. And so I'll just guess. And I guess I would say anything you put on Facebook, assume that the government or a plaintiff's lawyer will see. And so if you are doing something on Facebook that you are not supposed to do in a letter or an email or at an association meeting or on the MLS, assume that it's problematic in the same way. And there's nothing special or protective about doing it on Facebook.
Great. Well, thank you so much, Brian. I appreciate your time. We all appreciate your time, and we look forward to keeping in touch about what's next.
Absolutely. Happy to be here. Glad I could do it, and hopefully you all found it helpful.
Very helpful. Thank you so much, Brian.